Hello, my name is Caden. This is Castle Tutelage, your home defense network. We've been working on the premise recently about um, proportionality. A couple of months now ago, I made a video on the most common reason why people who defend themselves go to jail, and that's when self-defense turns into murder, and that's regarding proportionality. Um, this is the comment that comes up every once in a while, and they just never have the full picture, okay? And they get stuck up on what is reasonable in their head, okay? And this guy, he has knowledge. However, he doesn't have the complete picture, and it is giving him the wrong thing. I'm not picking on him. It's just he is the latest, and he provides his points, his bullet points, so I don't have to go look for them when other people just, skirt around it a little bit, okay? We'll just get right into it. As for proportionality issue, the example given, and the example given, if you remember, is that you're walking home in an urban city and you took a shortcut through, you're going to your car, you took a shortcut through an alley. A person half your size jumps out from behind a dumpster and says, "Give me your money." And then he pulls a gun, and as he's raising the gun, you manage to fire off 2 shots before he could do that. You hit him once. Um, the gun falls out of his hand underneath the dumpster, and he is no longer able to retrieve it. And then he stumbles. You shoot one more time, and you kill him, basically. And that's the basically idea. The premise of it with Michael Martin's book is simple. When does self-defense turn into murder? Well, my friends, that third shot is murder. That is not debatable. This is a lesson for the book. It's designed, the story is designed to entertain proportionality when self-defense turns into murder. Okay, so let's go. As your proportionality issue, the example given, it does not apply to in all situations. For example, I will change the location. I will change the location of the example. The book you use is written for Minnesota. Yes, true. The book is specifically written for Minnesota because Minnesota is a duty to retreat state. In order for you to have a successful self-defense event, you must be innocence, imminence, proportionality, avoidance, and reasonableness. Okay, you need up to all 5 of those to have a successful self-defense. Because in Utah, they have stand your ground, will excuse the avoidance. Okay, so the book that you use is for those in Minnesota. If you change the state to say it's Utah, you get a completely different outcome to the scenario. And this is where he cites a sample under the law of Utah. UCA 76-2-4021B, a person is justified in using force intended to likely to cause death or serious injury only if the person reasonably, now we're going to be listening to that word a lot, reasonably believes that force is necessary to prevent death or serious bodily injury to a person or a third person as a result of another person's imminent use of unlawful force or to prevent a commission of a forcible felony. Just because I have an unarmed assailant doesn't mean that the last round is unjustified. And he is referring to the third shot, the finishing shot, the murder shot in Michael Martin's book. Doesn't matter what state you're in. Again, here we go. If I reasonably believe, so if we go like this, if I, another word for I, is subjectively reasonably believe that the assailant is still attempting to commit a forcible felony, people, this is where his knowledge comes in. Forcible felonies, do not get caught in the weeds about forcible felonies. You seriously need to have a flow chart. That's why I don't talk about using deadly force on felonies. Other states are going to call it violent felonies. Some states will just say felonies, and it's left to assume that they meant violent felonies. Let's just say in California, if you steal $401 worth of watermelons, okay, Jim's example, it's the dollar amount, that's a felony. Are you going to shoot someone for stealing $401 worth of watermelons? So I think it's more going to be what his list is going to be. Again, do not get caught up in the flow chart, okay? And this is going to be the reason why. Most of the violent felonies or forcible felonies are going to be crimes against people. Therefore, we can use the self-defense statutes. We can use the self-defense of a third party kind of scenario. Do not get caught in the weeds about forcible felonies. You can know about them, but do not get caught in the weeds in it, okay? And here's his list, and we'll go through it. In Utah, forcible felony is defined as, for purposes of this section, a forcible felony includes aggravated assault against a person, mayhem, person, aggravated murder against a person, murder against a person, manslaughter against a person, kidnapping, person, aggravated kidnapping, person, rape, person, forcible sodomy, person, rape of a child is a person, object rape, person, object rape of a child, person, sexual abuse of a child, person, aggravated sexual abuse of a child is a person, aggravated sexual assault, a person. Now you have arson right here, okay? Arson, even though that it is a building, it is largely determined that there could be a person inside the building. Also, if you lose your place of abode, that is your sanctuary, that is your place that helps you stay alive, okay? Especially in the old times, if you were in Utah back in 1880, let's just say, and your house burnt down, there was you had a serious chance of possibly dying because of the elements or whatever, okay? So that's why you'll find arson in many of the approved felony use of deadly force, okay? Arson, robberies against a person, and burglary. Even though that burglary is generally taking things out of the home while the person's not there, it goes under the same heading as arson. But again, do not get caught in the weeds. In the example, it could range from robbery to murder with the information that was provided. Then I'm justified in using deadly force. Not really, okay? The example stated that the assailant dropped his weapon and then stumbled toward you. Him stumbling toward you could be seen as an act of aggression, and thus making it the third round justifiable. No, it doesn't. Okay. Innocence, eminence, proportionality, avoidance, and reasonableness. When he stumbled forward. Okay. Well, let's just get to my point with it. Okay. Let's just start in the middle of the sentence, and hopefully this is in the camera. Okay, we'll be starting here. So you can use deadly force in the defense of others. There is, I want to get down here. He is missing parts of it, okay? He is totally basing everything on subjectively reasonable. If he subjectively reasonable feels that his life is in danger, great bodily harm, just because someone stumbled forward, you can basically give him a finishing shot. Now, what he left out in Utah law is this. Section Utah 76.24025, A, B, and C. In determining imminence and reasonableness under this subsection, the tier of factor may be considered, but not as limited to any of the following factors: the nature of the danger. So, subsection A, the nature of the danger. This is where the AK-47, is he attacking you with an AK-47 or a marshmallow? Does a reasonable person believe that a person attacking you with a marshmallow is going to cause death or great bodily harm? Okay. That's where the proportionality provision of Utah law in. Okay, subsection B, the immediacy of danger. Again, this comes to, is the bad guy pointing a gun at you, or is he waving a knife 200 yards away? This is, you are not in immediate danger if the guy is waving a knife 200 yards away, but you are in immediate danger if you're getting a gun pointed to him. This is what I would like to say in subsection C. The probability that the unlawful force will result in the death of serious bodily harm. This is the word that you need to do. The probability. Probability means more probable than not, the 51%, okay? Does a guy half your size with a bullet hole in them more likely than not be able to kill you or seriously bodily injury? I'm not saying it's not impossible. There is a possibility of that person still killing you, but is it probable? No. Again, does an unarmed person going to be able to kill you when you have a gun? Okay, that is proportional force. Everybody recognizes the point where less than lethal force, okay, compared to lethal force. Let's just go, someone came after you with their fist and they hit you. That is non-lethal force, okay? You can only match that force. You know, there's other variables, disparity of force or a position of disadvantage, that kind of thing. We're not getting into those areas, but if everything is equal, if a person comes after you with a fist, your only option is a fist or pepper spray, that kind of scenario to defend yourself. Now, let's say that he came after you with a fist. You punched him. He comes out with a knife. Now it's deadly force. Now your gun can come out. Now it's the same way going backwards, guys. Okay? Let's just say that let's go with the scenario that the person half your size dropped the gun, doesn't have a gun at you anymore, but comes after you with the fist. Is that third bullet is murder? Okay, he de-escalated from deadly force to non-deadly force, or less than deadly force if you want to look at it that way, with his fist. Okay, this is a very common fallacy where people are believing that they are just taking a little bit, and let's go back up here. They are taking a little bit of the verbiage of a stand your ground black letter law, but don't understand the totality of the entire thing. And the totality of the entire thing for Utah is black letter law, okay? You may not, in your state, you may not have a black letter law like Utah has about innocence, eminence, proportionality, avoidance, and reasonableness. It may be from prior cases, precedent, could be in jury instruction. It could be amalgam of all of those, okay? So when I tell you that you cannot shoot an unarmed person that is half your size and a bullet hole in you, you can't shoot them until there is a disparity of force, or if that little guy has a position of advantage over you, okay? That's the most important aspect of it, is that he doesn't understand proportionality, and this is the reason why I made the video. For people who go on this, they read one section of the law and don't understand the totality of what actually needs to happen. In order for you to have a successful self-defense scenario, it's not a few lines of black letter lines on one section of a stand your ground law. And again, all stand your ground does is remove a duty to retreat. That's all it does. But you still must be the innocent party. You cannot be the provoker. You cannot have started it. You must be in immediate danger of death or great bodily harm. Proportional. You can only use proportional force to stop the threat. Okay. Avoidance. You must have a duty to retreat. However, only if it's safe to do so. I have a lot to say on duty to retreat. And I'll just say this: duty to retreat isn't that doesn't really matter in the fight itself, okay? Because if you are in immediate now fear of your life or great bodily harm, you don't have to look for a way out. You are in immediate death or great bodily harm. Duty retreat is irrelevant. Where stand your ground becomes important is the fight in the courtroom. Don't confuse duty to retreat as being some bizarre over, the law is telling me that I have to turn my back on the guy. No, that's not what the law is saying. It only says that if it's safe to do so. Okay, the typical example. Let's just say that the guy is screaming at, "I'm going to kill you, MF," and he's 100 yards away in his car running at you with a bat. And all you have to do is go inside your house and close the door. Compared to him having a gun on your sidewalk, 15 feet away, that's immediate. You need to deal with it now. So the duty to retreat isn't some bizarre thing that if the law forces you to do, but it becomes a problem when the prosecutor tries to make you prove a negative in court. That's like saying, prove to me God doesn't exist. Okay? How are you going to prove a negative? All right? And that's basically what the prosecution is going to try to ask you to do. They'll come in with a big board and, of the scenario. You could have gone this way. You could have gone that way. You could have gone this way and that way, this way, that way, this way. And that's why stand your ground laws are important, because it won't make you prove a negative. Okay? That's why it is. And the last one is reasonable. I'm going to say this once again. Reasonable is not always in between your ears. Subjectively reasonable. If I feel like my life was in danger of great bodily harm just because I have a feeling, I can use deadly force. No, you also need to have subjectively reasonable. It's going to be people looking at your actions after the event. There are going to be people that are looking, not personalizing it for you. Okay, there could be evidence that is pointing to you being objectively reasonable for justifying your subject actions. Okay, so again, I'm going to wrap this up. Do not get caught in the weeds about using deadly force to stop a felony. You're going to need a flowchart. I'm planning on making a video about using deadly force to defend your property. Again, you need a flowchart. There's going to be a difference from a state of Minnesota, and there's going to be a huge difference between if you look at the Texas codes for deadly force with for property and New York. You need to have a flowchart, and again, does it become worth it to you to be caught in the machine of the legal system for defending a piece of property? Okay, that's my diatribe on this. Again, do not get caught in the weeds with the flowcharts and using deadly force for defense of stopping a felony or defense of property. Innocence, eminence, proportionality, avoidance, and reasonableness. You need up to all 5 of those in every 50 states, okay, unless there is a provision for avoidance. We're talking Castle Doctrine or duty to retreat, okay? So do not fool yourself that the reason that you're justifiably reasonable to shoot an unarmed person with a bullet hole in them and half your size to kill that person because of reasonableness. Again, what is more probable than not? Okay, a guy half your size that has been shot and obviously can't move very well by stumbling. Is he more likely than not be able to kill you? The answer is no. Okay, that's why that disparity of force is in there. The classic 300-pound guy against a 98-pound person. Can a 350-pound guy take a gun out and shoot the 98 pound weakling. Yes, every once in a while, that 98 pound person can kick that 350 pound person's booty, but is it probable? Reasonableness? No. My name is Caden. This is Castle Tutelage, your home defense network. I hope this helped.